Well, the Assange hearing is back and going strong after its COVID hiatus, and oh my god, why is the press not covering this? I mean, first of all, this is like the extradition hearing of the century. There is so much happening that's so important. You know, all of the curtailment of justice and everything, but also because this affects the news media too, because if they can do this to Assange, they can do it to anyone, and this is just going to get more and more important as the days go on, and we'll see it. But we'll start with day 6, and I'm going back to Craig Murray's coverage because it's so good. He was actually there in the courtroom, one of the few people who were allowed in the courtroom and actually see what was going on. Starting on day 6, he says, "I went to the Old Bailey today expecting to be awed by the majesty of the law and left revolted by the sordid administration of justice." And he actually waxes poetic for a while about the Old Bailey, which is fine because he's a really good writer. I'm going to skip it because it doesn't really have that much directly to do with the hearing, but definitely read through this. He's a really good writer. And he says, "We in the court had no idea what had happened, but outside some consternation was underway in that the online access of Amnesty International, of Reporters Without Borders, of John Pilger, and of 40 others had been shut down. As these people were neither permitted to attend the court nor observe online, this was causing some consternation." Bareister, and remember I call her Judge Dalek, and I think that's going to end up being appropriate as well, went on to say that it was important that the hearing was public, but she should only agree remote access where it was in the interests of justice, and having considered it, she decided it was not. If they had remote access, she could not control their behavior, and this was not in the interest of justice. It is certainly true that an observer from Amnesty sitting at home might be in their underwear, might be humming the complete soundtrack to Mamma Mia, or might fart loudly. Precisely why this would damage the interests of justice we are still left to ponder, with no further help from the magistrate. So then there's this issue on calling the witnesses, and, I mean, of course that's a typical part of jurisprudence, right? We all know how that goes. Well, not in Bareister's court! The prosecution and Bareister both suggested that, having given their evidence in writing, there was no need for defense witnesses to give that evidence orally in open court. It would be much quicker to go straight to cross-examination by the prosecution. For the defense, Edward Fitzgerald QC countered that justice should be seen to be done by the public. The public should be able to hear the defense evidence before hearing the cross-examination. It would also enable Assange to hear the evidence summarized, which was important for him to follow the case given his lack of extended access to legal papers while in Belmarsh. Remember, they haven't been letting him know hardly anything that's going on. They've allowed him only very limited meetings with his lawyers. I mean, it's just horrible. So Bareister is saying that since this evidence is submitted in writing, there's no need to present it orally, but think about it. If you're a witness in a chair, if you've just given your evidence and you're being cross-examined, it's all like right at the tip of your head. Whereas if it was submitted in writing weeks ago, I mean, and we'll see this, you're going to have to refer to it, and I mean, that's just going to make that's going to give the prosecutor too many ways to bully you in cross-examination, and we will see that. So there was arguments back and forth for a while, and Bareister found against the defense witnesses giving their evidence in open court, but accepted that each witness should be allowed up to half an hour of being led by the defense lawyers to enable them to orient themselves and reacquaint with their evidence before cross-examination. And Murray says, "The idea that a standard half-hour guillotine is sensible for all witnesses, whether they are testifying to a single fact or to developments over years, is plainly absurd. What came over most strongly from this question was the desire of both judge and prosecution to railroad through the extradition with as little of the case against it getting a public airing as possible." So they've got all these new charges now, which is really not something you should be allowed to do. New charges should be a new hearing. You know, you have the hearing on one set of charges, then go ahead and have the... And I mean, this is just mission creep. It's like, hey, let's just add all this stuff in. Yeah, that's not how you do things. And I mean, it doesn't even help that the defense hadn't even been informed of this new indictment. They had only learned about it through a government press release. It wasn't even officially served until 6 weeks before these proceedings. And these are all new charges. They're standalone. They don't depend on the earlier allegations. So, I mean, really, it should have been submitted as a new case. You know, the defense has had no time to prepare or get witnesses, get depositions, things like that. A lot of the things they're talking about aren't even criminal, so. So after a whole bunch of arguments, Barister delivered her decision, which had been written in advance. We've seen that throughout this hearing. And Murray writes, "At the end of the day, I had the opportunity to speak to an extremely distinguished and well-known lawyer on the subject of Barister bringing pre-written judgments into court, prepared before she had heard the lawyers argue the case before her. I understood she already had seen the outline of the written arguments, but surely this was wrong. What was the point in the lawyers arguing for hours if the judgment was pre-written? What I really wanted to know was how far this was normal practice. The lawyer replied to me that it absolutely was not normal practice. It was totally outrageous." And he also says, "The question was, of course, whether it was her own pre-written judgment she was reading out or something she had been given from on high." And yet again, Barister's demeanor and very language made little attempt to disguise a hostility to the defense. So they take a break. They come after lunch. And this whole thing about not having time to deal with the new charges, she said, well, the remedy to that was more time. And so the defense comes back and says, well, okay, I guess we're applying for more time. Not that this hasn't dragged out long enough as it is. I mean, they could keep this going forever, just by bringing out new charges. And Murray says, they did not do this lightly, as Mr. Assange would continue in prison in very difficult conditions during the adjournment. Also, there's a problem with the defense actually getting the evidence, especially because of the COVID restrictions. And also, to this date, Assange had still not received the new prosecution opening note in prison, which was a crucial document setting out the significance of the new charges. Barister pointedly asked whether the defense should speak to Assange in prison by telephone. Summers replied yes, but these were extremely short conversations. They could not phone Mr. Assange. He could only call out very briefly on the prison payphone to somebody's mobile, and the rest of the team would have to try to gather round to listen. It was not possible in these very brief discussions adequately to expound complex material. Between 14 and 21 August, they had been able to have only 2 such very short phone calls. The defense could only send documents to Mr. Assange through the post to the prison. He was not always given them or allowed to keep them. And that should outrage everyone. I mean, they do that, and then they stick him in the cage at the back of the courtroom, and yes, the cage is going to come up again. She adjourned the court for a while to go and consider this, and ruled that the defense had not applied ahead of time to adjourn, but had applied to excise charges. They cannot have been surprised by my decision against that application, therefore they must have been prepared to proceed with the hearing. Their objections were not based on new circumstance. The conditions of Assange in Belmarsh had not changed since 21 August. They had therefore missed their chance, and the motion to adjourn was refused. Yeah, I mean, let that sink in. Yeah, They have basically no chance here. They got to go forward on charges that they really don't understand, having had no time to depose witnesses, prepare witnesses, things like that. So, Murray says, the courtroom atmosphere was now highly charged. Having in the morning refused to cut out the superseding indictment on the grounds that the remedy for lack of time should be more time, Barister was now refusing to give more time. Barister, Catch-22 is not a legal manual. The defense had called her bluff. The state had apparently been confident that the effect of solitary confinement in Belmarsh was so terrible that Assange would not request more time. I rather suspect that Julian was himself bluffing and made the call at lunchtime to request more time in the full expectation that it would be refused and the rank hypocrisy of the proceedings exposed. Alright, so they move on to the first witness, Mark Feldstein, giving evidence by video link for the United States. Except the court couldn't make the video technology work. He was only able to speak very briefly on and off, so really they left it off for day 7. So on day 7, they have the testimony of Clive Stafford Smith, and he had testified to good things about the WikiLeaks publication before, which Murray goes into, but I'll kind of focus on his testimony here. But he talks about the drone strikes of U.S. assassination attempts with Hellfire missiles and Guantanamo and the evidence that detainees there are not terrorists, but were just swept up, by the actions in Afghanistan. Now remember, he's only got 30 minutes to speak. So, Judge Dalek has to give him the 5-minute warning before that's crazy. That's crazy. Witnesses should be allowed to speak however long they think, But Stafford Smith went on about how a lot of these leaked documents revealed illegal kidnapping, rendition, and torture and had been used in trials, and the International Criminal Court had opened an investigation into war crimes in Afghanistan, and the WikiLeaks material played a big part in that. And Smith had said that the U.S. had made an executive order issuing sanctions against any non-U.S. citizen who cooperated with or promoted the ICC investigation into war crimes by the U.S., and suggested that Mr. Summers would now be subject to U.S. sanction for promoting this line of questioning. So then his 30 minutes was up, and Murray links to his defense statement there, and get it while you can, because apparently, we'll get to that later. I'm just going to say right now, if anyone has links to the full testimony from all of these witnesses, please post it below. So, not going to give spoilers, but something amazing like that happens a little later. So Lewis cross-examined Smith and said that although he was arguing that WikiLeaks disclosures were in the public interest, there was specifically no public interest defense allowed in the UK Official Secrets Act. Stafford Smith replied that may be, but he knew that was not the case in America. Because remember, this is about America being extradited to America to face charges in America. So a lot of this is going to center around this affidavit by U.S. Assistant Attorney Kronberg. I mean, they're just going to keep coming back from this. So Lewis reads out part of it, saying that Assange was only being indicted for cables containing the publication of names of informants. Remember that. This is going to be important. It's all about the publication of names. So Stafford Smith replied that the charge was of conspiracy, and the way such charges were defined in the U.S. system would allow the widest inclusion of evidence. The first witness at trial will be a terrorism expert who would draw a wide and far-reaching picture of the history of the threat against the USA. So Lewis had said that the cables he had quoted were published by the Washington Post and the New York Times before they were published by WikiLeaks. Stafford Smith responded that was true, but those newspapers had obtained them from WikiLeaks. Because WikiLeaks, as we'll hear more about later, was actually working with the Washington Post and the New York Times and others. So Lewis quoted Kronberg again, saying, "The only instance in which the superseding indictment encompasses the publication of documents is where those documents contain names which are put at risk." And Stafford Smith again said that in practice that's not how it would be prosecuted in the United States. And then Lewis asked if Stafford Smith was calling Kronberg a liar. At this point, Julian Assange called out from the dock, "This is nonsense. Count 1 states throughout conspiracy to publish." After a brief adjournment, Judge Dalek warned Julian he will be removed from the court if he interrupted proceedings again. Do you remember the earlier days of the hearing? All those months back when we were talking about the dock, when we were talking about that locked cage they have Julian in, where he can't even communicate with his lawyers or participate in his defense. What did Judge Dalek say? She said it was just fine because he could always call across the court and make any points he wanted to make to his lawyers. Well, now, here he is trying exactly that, and Judge Dalek shuts him down. So, yeah, he's got no chance at all to participate really in any way in his own defense. So Lewis reiterates, nobody is being prosecuted for publishing except Assange, and that's only because he published names. Stafford Smith stated that Kronberg's assertion that the ICC investigation was a threat to national security was nonsense. Lewis suggested that the question of harm to U.S. national interest from Assange's activities was best decided by a jury in the United States. The prosecution had to prove damage to the interests of the U.S. or to help an enemy of the U.S. Stafford Smith said, beyond the government adoption of torture, kidnapping, and assassination, he thought the post-2001 mania for overclassification of government information was an even bigger threat to the American way of life. And he goes on to a client he had where his torture was classified secret on the grounds that it would damage American interests if people knew that he was being tortured. Lewis then goes to a book, WikiLeaks, Inside Julian Assange's War on Secrecy, and he quotes them of quoting Assange of saying, They were informants, so if they got killed, they have it coming. And repeated again that it was only about the publication of names. Stafford Smith said that he would eat his hat if that was all that was introduced at trial. So, re-examination, finally they get to properly talk to their own witness. So Summers said that Lewis had characterized the disclosure of torture, killing, and kidnapping as in the public interest. Was that a sufficient description? Stafford Smith said no. It was also the provision of evidence of crime, war crime, and illegal activity. And so Stafford Smith again repeated his rather different point that in practice, Kronberg's assertion does not actually match how such cases are prosecuted in the U.S. anyway. In answer to a further question, he repeated that the U.S. government had itself released the names of its Guantanamo Bay informants. Then you go on to Feldstein, again trying to get in through all of the glitches and everything now, so... Feldstein is saying that this kind of leaked information happens all the time in the United States. Government officials do it frequently. One academic study estimated such leaks as thousands upon thousands. There were journalists who specialized in national security and received Pulitzer Prizes for receiving such leaks on military and defense matters. Leaked material is published on a daily basis. And Feldstein stated, "The First Amendment protects the press, and it is vital that the First Amendment does so, not because journalists are privileged, but because the public have the right to know what is going on." And historically, the government had never prosecuted a publisher for publishing leaked secrets. They had only prosecuted whistleblowers. There had been historical attempts to prosecute individual journalists, but that had all come to nothing and had been a specific attack on a perceived presidential enemy. So then he provides, a lot of evidence on the blockbuster newspaper stories, the videotape of soldiers firing from the helicopter, and all of that. They're listed here in bullet points in the article, so you can read over those yourself. But, they're horrible. They're absolute criminal war crimes. People should be in prison for life because of that. And, of course, they aren't. That somehow never happened. That got forgotten during all this. So Summers asked Feldstein about Assange being charged with soliciting classified information. Feldstein reported that gathering information is standard operating procedure for journalists and said, "My entire career virtually was soliciting secret documents or records." And one accusation was Assange helped Manning cover her tracks by breaking that password code. Remember we talked about that? He said, "Trying to help protect your source is a journalistic obligation." And he said the journalists would provide sources with payphones, fake email accounts, and help them remove fingerprints, both real and digital. These are standard journalistic techniques taught at journalism college and workshops. Summers asked about the disclosure of names and harm to people. Feldstein said that was easy to assert, hard to establish. Government claims of national security damage were routinely overblown and should be treated with skepticism. In the case of the Pentagon Papers, the government had claimed the publication would identify CIA agents, reveal military plans, and lengthen the Vietnam War. All of those had proven to be untrue. And they go into the fact that the Obama administration declined to prosecute over this. And they certainly had plenty of time to do that, and they had instigated an aggressive investigation. But they concluded that the First Amendment basically made any prosecution impossible. And Justice Department spokesman Matthew Miller had published they thought it would be a dangerous precedent that could be used against other journalists and publications. But that all changed with the Trump administration, and we went into that before, and we'll go into it again a little later, so I'll just kind of gloss over it now. But we've got Lewis cross-examining Feldstein now. It says, he adopted a particularly bullish and aggressive approach and started by asking Feldstein to confine himself to very short, concise answers to his precise questions. Sorry, no, you do not get to do that. Witnesses get to answer questions in full. They get to talk for as long as they think they do in order to deliver the truth, the whole truth, and nothing but the truth. But as we'll see, Lewis is going to continue to try to bully everyone into short answers that he can manipulate. So he said that Feldstein claimed to be an expert witness and asserted that he had read the criminal rules. Could he tell the court what those rules said? And Murray says, "This was plainly designed to trip Feldstein up. I am sure I must have agreed to WordPress's terms and conditions in order to be able to publish this blog, but if you challenged me point blank to recall what they say, I would struggle. However, Feldstein did not hesitate, but came straight back saying that he had read them and they were rather different to the American rules stipulating impartiality and objectivity. So they go in to the question of his expertise, and then you've got Feldstein, like the other witness, saying that he hadn't had a chance to read the most recent indictment because they just sprang it on them. So Lewis said that about Obama deciding not to prosecute Assange, but Trump did. He said it was clear the investigation had continued from the Obama to the Trump administrations. Feldstein replied yes, but the proof of the pudding was that there had been no prosecution under Obama. So Lewis talks to a Washington Post article that Feldstein had included in his footnotes, but hadn't appended a copy. He said, "Was that because it contained a passage you did not wish us to read?" And that passage was saying that no formal decision had been made by the Obama administration. So, I mean, he's rattling Feldstein. And he replied that his report stated that the Obama administration did not prosecute, which was true. He had footnoted the article. He had not thought he needed to also provide a copy. He had exercised editorial selection in quoting from the article. And so Lewis goes into the question of all these details and why they weren't included in the report. And Lewis asks if the Obama administration had decided not to prosecute, why would they keep the grand jury open? And Feldstein said, well, that happens all the time. It could be for many reasons, including to collect information on alleged co-conspirators, or simply in the hope of further new evidence. And by the way, as he pointed out, there has been no new evidence for years, since well before the Obama administration ended. And Lewis continued that the New York Times problem did not exist because the NYT had only published information it had passively received. Unlike Assange, the NYT had not conspired with Manning illegally to obtain the documents. Would Feldstein agree that the First Amendment did not defend a journalist against a burglary or theft charge? Feldstein replied that a journalist is not above the law. Lewis then asked Feldstein whether a journalist had a right to steal or unlawfully obtain information or to hack a computer to obtain information. Each time Feldstein replied no. Lewis then asked Feldstein if Manning had committed a crime. Feldstein said yes. And then Lewis says if Assange aided and abetted, consulted or procured or entered into a conspiracy with Manning, has he not committed the crime? Feldstein said that would depend on the sticky details. And we see a lot of this. Lewis is trying to ask very simplistic questions, the answer to which depends on a lot of details about what's going on in the context and everything. So a little later, he goes back to the name thing. Lewis asks, would a responsible journalist publish unredacted names of an informant knowing he is in danger when it is unnecessary to do so for the purpose of the story? Feldstein replies no. And then Lewis went on to list examples of information that might be proper for government to keep secret, like troop movements in war, nuclear codes, things like that. And then goes on to make a big deal about how the grand jury has supported the prosecution. And says, do you accept that there is an evidentiary basis for the prosecution? Feldstein replied, a grand jury has made that decision. I don't know that it is true. And of course, remember the old saying that a grand jury will indict a ham sandwich. So if you're going in front of a grand jury, you're getting indicted. Well, unless you're a cop, they don't indict cops for whatever reason. But whatever. And then he goes back to Kronberg, saying that prosecutors preclude political factors when they prosecute. And Feldstein replied, that is a naive view. And said it was a political prosecution based on its unprecedented nature, the rejection of prosecution by Obama, but decision to prosecute now with no new evidence, the extraordinary wide framing of the charges, and Trump's narrative of hostility to the press. Summers now gets back up to re-examine Feldstein and asks, is it your understanding that to seek to help an official leaker is a crime? Feldstein replied, no, absolutely not. Do journalists ask for classified information? Yes. Do journalists solicit such information? Yes. Are you aware of any kind of previous prosecution for this kind of activity? No, absolutely not. Could you predict it will be criminalized? No, and it is very dangerous. I mean, that's ultimately the nub of the matter, which is why, Lewis has to keep blowing smoke all over the place. But he mentions Dan Ellsberg, who will testify later, and the Pentagon Papers. And they had been very active in soliciting the papers. They even had a key to the room that held the documents and helped to copy them. And he said, journalists are not passive stenographers. And going to the hacking, we've talked about this before. The whole point of hacking that passcode wasn't to get the documents. Manning could get the documents. Manning had already seen the documents. It was about getting the documents in a way that disguised the source so that hopefully Manning wouldn't get, exposed, which is what happened. But that's what happens, Feldstein says. Journalists work closely with, conspire with, cajole, encourage, direct, and protect their sources. That is journalism. And then they go on about WikiLeaks releasing the unredacted cables, and Feldstein clarified that his answers were not intended to indicate that he had accepted the government narrative. Fitzgerald then took over for the defense and said that the Washington Post article that Lewis had accused him of selectively quoting also contains more material Feldstein had also not quoted, but which strongly supported his case. For example, officials told the Washington Post last week that there is no sealed indictment, and the department had all but concluded that they would not bring a charge. And it further stated that while Snowden was charged, Greenwald was not, and the same approach was followed with Manning and Assange. And Fitzgerald concluded by asking if Feldstein were familiar with the phrase, a grand jury would indict a ham sandwich. Feldstein replied it was common parlance and indicated the common view that grand juries were malleable and almost always did what prosecutors asked them to. And there's a great deal of academic material on this point. And that'll also come up in later days as well. But this video is getting on, so I'm going to leave it here for now and come back in a future video and discover day 8. But, if you think this is ridiculous, it's only going to get worse. And especially Lewis. Man, the guy just gets unhinged. You have to hear this. So, thank you so much. If you like what I do, please go to donate.pagosity.tv and give everything you have. And until next time, stay strong and be free.